let's raise the big questions then tonight with top lawyers. Bail first step to justice for Rhea? Is the High Court order a blow to the Narcotics Control Bureau? Will Rhea Chakraborty continue to face an abetment to suicide charge in the Sushant case? Is this a temporary reprieve, or has she genuinely now got a chance of real freedom? These are questions I will raise. Satish Manashinde, Rhea Chakraborty's lawyer, is with us. B.V. Kumar, former Narcotics Control Bureau chief, with us. Rizwan Merchant, Mumbai's leading criminal lawyer in drug-related matters. C.A. Sundaram, Aryama Sundaram, senior advocate, Supreme Court, joining us. All four fine minds joining me. Satish Manashinde, to you first as Rhea Chakraborty's lawyer. Am I right to say that you have got temporary relief, that this is hardly a finality or a closure? Can you at this time claim, as you have in your first remarks after the order came, that this is a victory for Rhea Chakraborty?
Well, I must tell you that after the 14th of June 2020, Rhea Chakraborty has been investigated by the Mumbai police. They did not find anything against her. The Patna police tried to get into the picture. They could not. Thereafter, the ED came into the picture. CBI has investigated her. The ED came into the picture and then investigated her thoroughly. And thereafter, the NCB has come into the picture. So she has been hounded by almost about 5 agencies. Firstly, she was the target of all the 5 investigating agencies. And to tell you the truth, Rhea Chakraborty has stood steadfast in the entire battle with all these 5 agencies. The Mumbai police obviously did not find anything against her because they came to a conclusion that it was a suicide by hanging. And the doctor said that is asphyxia causing the death. And therefore, there was no foul play as declared by the Home Minister of Maharashtra. The Patna police tried to hound her. They were not allowed to investigate because they had not taken permission from the Mumbai police, according to law. Then the CBI went after her and they investigated her for about 5 to 7 days. They did not find anything contrary to what the Mumbai police had found so far. And the ED questioned her a number of times and started a systematic leak of her mobile messages to various agencies and in the public domain. Thereafter, the NCB came in. So till she was arrested 1 month back, none of the agencies had found anything against her. So I presume that there is nothing against her, either in the books of CBI or in the books of ED, to involve her in any offense.
No, are you saying, therefore, are you telling me today that you believe her arrest and custody in a narcotics case was totally unwarranted in the first instance? The judge today has, in a sense, said that there is no evidence that she financed illicit trade of drugs or harbored drugs, but they have not yet in any way lifted the charges against her. Let's be very clear about that. This is bail.
Well,
This is not an acquittal.
The finding of the learned judge prior to granting bail is that she is not likely to commit any offense once on bail. Secondly, there is nothing to come to a conclusion that she is guilty of an offense punishable for an offense either under section 27A or for a commercial quantity. At the most, according to the judge, she can be prosecuted for an offense under section 18 and 22 of the Narcotic Substances Act. So those offenses deal with minor offenses. Apart from that, the learned judge has come to a conclusion that if a person was consuming drugs according to the Narcotics Control Bureau could be granted immunity if he was alive, how can you punish a person who was either procuring for it, procuring it for him, or making payment? The only allegation against her is that she was involved in a payment of 27,000 rupees in 3 different transactions, and she had given a few telephonic SMSs and messages to the servants to exchange or procure the drugs. So how can a person? The judge also asked a pertinent question during the hearing that if the father were to procure drugs for his addict, which in this case, the addict is Sushant Singh Rajput because he is consuming it for more than 4 to 5 years. It is known that Sushant Singh Rajput was habituated to drugs and addicted to drugs because of his flatmates who were living with him 4 to 5 years back. And this evidence has been shared with the NCB that when he went for the shooting of Kedarnath movie at Kedarnath, he got into a much bigger habit of consuming drugs because the best quality of drugs, according to him, available was in Kedarnath. So if such a person who was under medication of 5 doctors could not give up his habit of addiction in narcotics, how can Rhea Chakraborty be even charged for an offence under the NDPS Act?
Okay, you made your point. Let me turn therefore to the NCB former NCB chief B.V. Kumar. He is the person who many credit with building the Narcotics Control Bureau. Do you believe, and you come on my program, Mr. Kumar, saying you were surprised in the first instance that Section 27A of the NDPS was applied against Rhea Chakraborty, financing and harboring drugs, which made it non-bailable. Do you believe today the judge, in a sense, has put a little rap on the knuckles of the NCB for putting Rhea Chakraborty under 27A when the evidence, as the judge says, simply does not exist? Simply, as the judge says, and I'll put the observation, simply providing money for a particular transaction will not be financing of that activity. The word financing would necessarily refer to some activities involved in illegal trade or business. They don't see Rhea Chakraborty at any stage involved in drug dealing. To that extent, did the NCB try and fix Rhea Chakraborty in under 27A, and have they received more than a rap on the knuckles?
Oh, thank you, Ms. Rajbi. I had the benefit of going through the judgment, which runs into almost 70 pages. And I think it's an outstanding decision and interpretation of Section 37 of the NDPS Act, which in fact says the drug offenders will not get bail. But there are also in the subsections where it clearly says the prosecutor should be given an opportunity to oppose the bail. And even if the prosecutor opposes the bail, if there are reasonable grounds to say that the person accused will not commit an offence while on bail, the judge has the full liberty to grant bail. And this right to grant bail is only with the High Court and not with the lower court, that is the special judge appointed under the NDPS Act. So, and not only that, he has really laid down how exactly Section 37 should be interpreted in the course of investigation, or in cases where a person is charged for offences under Section 19 or 24 or 27A. Now, 27A talks of harboring. I was rather amused that the learned Assistant Solicitor General mentions that if a person is consuming drug and if it is not informed to the authorities concerned, it amounts to harboring a drug addict or a drug offender.
Right.
That is too far-fetched to give such an interpretation under Section 27A. Harboring drugs would really involve like harboring a real criminal offender in your house or in your premises, which is under your control, and not informing the authorities, and fully knowing fully that the person has committed a serious offence, not a person involved in this particular case, where
so to that extent, that's my point, Mr. B.V. Kumar. To that extent, after this order, this bail order, it's not an acquittal, it's a bail order. Is the NCB being in some way being told that you overextended your hand? If 27,000 rupees are paid to procure drugs in small quantities amounting to, let's say, 59 grams, is that enough to accuse you of financing and harboring? Did the NCB, in your view, try and fix Rhea Chakraborty? I want a straight answer to that, to make it non-bailable when it was clearly a bailable offence.
No, we have to sort of go to the background in which she procured drugs for Sushant Rajput. For the simple reason, he was a confirmed drug addict, and without drugs being available at the proper time, he gets into what you call a withdrawal symptoms, and a person can become violent, he can become depressed, and so many other what you call, he may be prone to violence also. So probably she procured these drugs and for being given to him so that he is under control and probably he will come back to his normal senses. Because a drug addict, when he doesn't
Sir,
have
you're
the
not,
drugs at
sir,
the right time.
sir, you're being very diplomatic. I am asking you a
No,
straight
it's not
answer,
financing
sir.
at all.
The
It's not
country's
financing
leading narcotics agency, which is supposed to handle interstate drug connections, did they try and fix Rhea Chakraborty by putting 27A financing and harboring drugs when they knew she was not doing it?
Which is not correct. According to me, it's not correct. That does not amount to financing. The Honorable High Court has also said that she has not procured the drugs for any monetary consideration or monetary benefit for her. So it does not amount to financing, procuring of drugs, either for benefit or for resale or any other
So
purpose.
I'm going to push you one
Very
more
clear.
time. Why do you think the NCB did it then? Why do you think the NCB
Well,
put 27A
there must have
when
been
it's
a
a
motive
when it's a seemingly cut and dried case that at best she was procuring the drugs for Sushant Singh Rajput, that at no stage was she harboring drugs? Why did they do it?
I think they were under influence or pressure from some other force that may be. But what the NCB did probably was a little far-fetched, and it was a simple case where a person probably procured drugs to keep a drug addict probably under his control,
Right.
which was necessary as a medicine at that point of time. By
So that's
providing
what-
that particular drug, and that too in small quantities.
That's what I was waiting to hear, that they were, let's be honest, let's call a spade a shovel today. That's exactly what it appears has happened. There was some kind of pressure on the NCB to apply Section 27A. But Aryama Sundaram, very interesting what the judge also goes on to say. And it is in the context of so-called celebrities. The judge makes it clear the learned ASG had argued that celebrities and role models should be treated harshly so that it sets an example for the young generation and they do not get encouraged to commit such offenses. The judge says, I do not agree. Everybody is equal before the law. No celebrity or role model enjoys any special privilege. Similarly, such person also does not incur any special liability when he faces law in the court. Each case will have to be decided on its own merits. How do you respond? To that extent, has the judge set an important precedent that it's not about someone being a celebrity or someone not being a celebrity, it's about the merits of the case?
Well, I think it goes without saying, Rajdeep, that every case has to be decided on its own merits. Justice is meant to be blind. What does that mean? It means that justice doesn't look at the face of the person who's committed the crime, looks at the facts and looks at the crime itself. So I think the judge stated nothing but a truism. But let me also say one thing. I must say that you were being very gentle when you said that the judgment wrapped the knuckles of the NCB. I'd rather think it was a slap on their face. Because let me tell you something, that in such a bail order, for such findings to be given even prima facie by a court, is quite extreme. Usually in a bail order, what you really look for is as to whether the person can be enlarged on bail, whether the crime is so heinous that their continuation in jail is necessary at that time, whether investigation will suffer, whether evidence can be tampered with, whether they will flee from the jurisdiction. These are factors which one looks at when a person is applying for bail. For the judge to have gone into such depth actually shows that there was so little in that complaint that the judge was forced to remark that, look here, I find that what all you have been saying is hardly made out at all. And what you're really catching someone for is that they really procured the drugs for their loved one who was a drug addict. And in this context, I find it really ironical and sad that what started as a Justice for Sushant campaign has now become Sushant was a drug addict. Sushant was a drug addict who used his friends, who used people around him, who used his woman friend, his partner, to procure drugs for him to keep him in the drug habit. And I'm sorry to say that if the aim of his family was to get justice for Sushant, his family has managed to tarnish his image after his death, which I think is very, very sad. But what is even more sad is that it's almost like a gun is pointed and it has to shoot somewhere. And this girl has got caught in that fire play. After having the CBI is not able to progress, the ED is not able to progress, and now they catch her on so-called drug charge, where even if you looked at the complaint on the face of it, it really doesn't make out the offences she's been accused of. All it can make out really is that she helped her partner in getting the drugs that he needed. And that is all she has done. And here, let me point out a difference to you, Rajdeep. There's a difference between a person who gets drugs for somebody whom they don't know, who calls up and says, look, get me drugs. So in that case, they can be a supplier. But someone who gets drugs for their own partner, it cannot be that they're a procurer or a supplier. What they're really doing is that, look, how many women would, Indian women especially, and I'm not being misogynist here, how many Indian women would refuse their man when their man wants them to do something? It's a truism, it's a reality which happens. And I think this girl getting caught in this crossfire of this aim at shooting somebody for Sushant Singh Rajput's death is very unfortunate, that the NCB should have wasted my money, your money, taxpayers' money on this kind of thing.
You know, it's interesting you're saying that, because I want your response, and I'll get you in, Rizwan, also in a moment, because this is what the lawyer of Sushant's family, Vikas Singh, has done today. He has written to the CBI director demanding a new forensic team to do a fresh study. The NCB has said they will appeal in the Supreme Court. Remember, Singh has now sought a probe against the AIIMS head, Dr. Sudhir Gupta, and said if his demands are not met, he will also move the courts. So Sushant's family is coming up with more demands. Listen into what Vikas Singh says, and then I want to get some more responses. Listen in for a moment.
We on behalf of the family have written to the CBI director to constitute a fresh forensic team to look into the reports prepared by the Cooper Hospital, and also to give an opinion as to whether the opinion given by the Cooper Hospital can be sustained or not, or whether there are some infirmities in that report, or whether the death can be said by hanging, or it can be said to be murder, that is death by strangulation.
Quick response, Aryama Sundaram. You've got the family and its lawyer still maintaining that Sushant was murdered. You've got the NCB saying they'll go and appeal. Your quick response to that, and then I'll come to you, Rizwan.
Well, like I said, a gun was pointed and that bullet had to hit something. And so the NCB got into the act and said, at least here, let's hit. Because the fact of the matter is the CBI was asked for by Sushant Singh Rajput's family. The ED came into it. ED has got nowhere. The CBI has also said this. So it almost sounds like, look, I want one forensic examination after another. I want an investigation by one body after another until she is found guilty. Until this is the conclusion. It's almost like saying, this is the conclusion. Now I need the evidence to show that conclusion. So as long as the forensic tests, etc., don't show it, that test is bad. Keep going on and on and on testing until you find that what I feel and what I'm accusing her of is correct. I think this is a wrong way to go about the whole thing. It's putting the cart before the horse.
Okay. Can I just also bring you in, Rizwan Merchant? Because the fact is that while Rhea Chakraborty gets bail, her brother does not. And the sense is that the brother is being linked to a chain of drug peddlers. So therefore, if I am in direct communication with the drug peddler and procure the drugs, then I can have section 27A and it becomes non-bailable. Do you see the distinction as a valid one between Rhea Chakraborty, who procures the drugs for Sushant Singh Rajput allegedly, and her brother who is in direct touch with the peddlers? Are they two very distinct cases in your view?
See, Rajdeep, the order of the learned judge has been based on interpretation of certain questions of law. Those questions of law have been interpreted by the learned judge based on the facts of the case, which have been put up by the NCB before the learned judge for consideration. Now, one of the material which the learned judge was confronted with were the statements under section 67 of the NDPS Act, on the basis of which the learned ASG was basing his arguments for the learned judge to give a particular finding in favor of NCB that there existed material against Rhea as far as financing is concerned. Now, the orders which have been delivered by the learned judge are distinct, separate and independent for each of the accused. While you read the orders of Rhea, Samuel Miranda and Dipesh Sawant, you will find that the learned judge has made it very, very clear that there was no material whatsoever to suggest that either of them were involved in financing. Learned judge has gone categorically differentiating financing from other activities. Any particular activity where a person invests his money expecting a particular return in exchange for his investment is something which you can say that he is investing. As far as financing is concerned, there was no material against Rhea or either Dipesh or Samuel Miranda.
Dipesh, for our
but on
viewers,
the
was
other
the cook
hand,
and
when the
Samuel
learned
Miranda
judge
is the
was
house help.
confronted with the statements under 67, yeah. Now, as far as the material against the other two is concerned, Shovik and Parihar, the entire reliance was placed on the statements under section 67. Though they were retracted statements, but the learned judge felt that at this particular point of time, the retracted statement is not something which can be invited for any particular observations. It is something which is open to evidentiary scrutiny at the time of the trial.
Right.
Now, as far as the attempt by Vikas is concerned, this is something which is very shocking. Rajdeep, let me tell you, Supreme Court has been very clear, saying that investigation has always been considered by the Supreme Court as the prerogative of the investigating agency. Now, it is the investigating agency which can either voice its satisfaction or dissatisfaction about the nature of evidence which is being collected. If they are satisfied, they go ahead with the final report. If they are not satisfied, they can conduct further investigation of 173(8). I understand CBI is spearheading the entire prosecution for and on behalf of the complainant. But that does not give latitude to the complainant to adopt this policy of pick and choose, that A, evidence is something what I'm accepting, B, evidence is something which I'm rejecting, I'm not happy with the Ames report, so you constitute a fresh forensic team. This is not the task of the complainant. The complainant is supposed to cooperate with the investigating agencies to facilitate closure report or to facilitate the filing of a final report. This is something which has never happened in the past and should not be allowed to happen in the past.
That is, that is something that Vikas Singh will have to answer.
Something very important. I'm sorry, Rajdeep, something very important.
Yes.
Yes, something very important. Your question as to why NCB did this with Rhea. See, under section 69, the statute has given a protection to an officer of the NCB, that anything and everything which you do under the protective umbrella of investigation under NDPS Act is deemed to have been done by them in good faith. Comparatively, if you see section 166 capital A of the Indian Penal Code, there is an opening provided by the statute that if a police officer does something which is not warranted during the course of investigation, he can be prosecuted. Now, this is missing under NCB, under NDPS Act. That is one of the reasons why they have taken the latitude and they've taken the liberty that when there was no material against Rhea, either with CBI or with enforcement or with any other department, you drag her into this NCB on the grounds of financing. Where is the question of financing?
No, there is a very, that's a very, very important point you're making, Rizwan. That's a very important point you're making. If the investigators have not acted in good faith...
Good faith, they are taking advantage of the element of good faith, that's all.
Yeah, you know, Satish Manishinde...
They are taking advantage of the protection which is given to them by the statute.
I take your point, but at this stage, perhaps we would be jumping ahead to suggest that the investigators did not act entirely in good faith, even though the suspicion is that they certainly did not display good faith. I want to understand from you, Satish Manishinde, what next?
I agree with you, Rajdeep. You see, as far as those who were found in possession of material, I can understand that they were in possession, so you have a different approach to them. But as far as those against whom you have only material based on your statement under section 67, we know how you record the statements under 67.
So your point is taken.
So
your point is taken. Let Satish
have been.
Let Mr. Manishinde respond. Mr. Manishinde, what next? If it is suggested that the NCB did not act in good faith, is that something that you intend to pursue?
I have said right from the first day that Rhea Chakraborty is being hounded by central agencies, obviously with a view to arrest her in some case or the other. And it happened right in front of us in the NCB office. They called her for 3 days. They gave her sweet stories. I have also made allegations against the NCB officers in the connected case of Kshitij Prasad, that the NCB threatened him that if he did not name film stars and people from the Bollywood, they would arrest him, which happened. So therefore, the investigations are totally Malafide. They're not conducted in an honest manner. And I'm going to go after each and every officer who has been, hounding my client. And I will list them all once. Are
you telling me that you intend to prosecute the NCB officers if necessary?
If I find a material which I feel I suspect that is enough. I will actually take action against those officers.
You know, B.V. Kumar, here you have Rhea Chakraborty's lawyer now saying it's the NCB which must be prosecuted in a way. While the law itself may not provide it, other sections under the IPC do provide it. Police officers are seen not to act in good faith. According to the lawyer here on the program, Satish Manishita is saying NCB was forcing Kshitij Prasad, for example, to name certain Bollywood stars, saying they were consuming drugs. This is not what the NCB is supposed to be doing. What does that say about India's premier agency, sir?
I have to leave.
I fully agree with the learned senior counsel, Mr. Mansinde,
Yes.
that the officers, either of the Customs Department or of the NCB or for that matter, any government agency, act in a vexatious manner, they are liable to be prosecuted. And in this particular case, allegations were made by Prasad that he was harassed, he was threatened if the names of certain film stars were not mentioned. To that extent, I think he was right in case he is able to prove that there was vexatious behavior on the part of the investigating agency or its officers. That will apply to all departments. Now, I wanted to make one small point. There was a recent decision of the Honorable Supreme Court in the case of Sujit Tiwari versus Government of Gujarat. It's a Supreme Court decision which came in January, 20th of January 2020, where they make two very interesting observations. In fact, in that particular case, the brother of the appellant was a captain on a ship in which 1,445 kilograms of heroin was found, not even hashish, heroin was found. And this brother of the accused was on the shore in Porbandar, and he was also charged, kept in jail for 2.5 years. The Honorable Supreme Court observed that the statements recorded under Section 67 of the NDPS Act is before a larger bench of the Supreme Court, and they have to decide whether they are admissible in evidence or otherwise. The second observation they made was the only other evidence that's available is in the WhatsApp messages between Sujit Tiwari and his brother Supreet Tiwari, who was the accused. So they said that's not enough to keep this person on bail. He's a young man, he's a B.Tech, he's an engineer, and probably he has to pursue his career in
He spent, sir, correct me if I'm wrong, sir, he spent 2.5 years in jail?
And unfortunately, the Supreme Court came to his rescue and granted him bail and very, very clearly said that WhatsApp messages are not enough to keep him in custody. Yeah. And they also said statements under Section 67, whether it's admissible or not, is before the larger bench of the Supreme Court. Until such time, the situation is a little dicey.
These are very, very interesting elements that are coming in this case. I want to get you in, Aryama Sundaram, at this moment. As a final word on this, is this therefore a wake-up call to our agencies that caught in this sensationalism of the media, caught in this entire trial by media, that the slander that has gone on, that even the criminal justice system gets caught in it, including the country's leading agency? We are not saying Rhea Chakraborty is innocent, but clearly prima facie it appears at the moment that the NCB has not acted in good faith. What is the message then? Today it's Rhea Chakraborty, tomorrow it could be anyone else that they want to fix.
Rajdeep, I'm very sorry to say that this is something not new, this feeling. For a long period of time, people have suspected the bona fides of the police. People have suspected the bona fides of various authorities, various organizations. In fact, if you remember, the CBI itself was a body which came under so much criticism that it was even the expression given by a judgment by an order of the Supreme Court was they were like caged parrots. So actually, if you look at it that way, public perception has for a very long time lost faith in all these agencies. And what worries me is when the NCB, which should be doing much larger issues, gets involved in calling Bollywood stars to parade before them as though it's a modeling ramp. It really worries me that when the NCB is spending your money and mine and taxpayers' money to find out which Bollywood actor is consuming drugs and who's not, naturally, people are going to suspect the very bona fides of such organizations. And the whole, what is most upsetting about it is they are bringing this on themselves. Whether it's the NCB, whether it is other investigative authorities, they are bringing it on themselves by the manner in which they conduct investigations.
Well, someone is calling...
And a case like this
Yes.
is really a pointer. It's really a pointer to what the NCB is all about.
Well, the word that has been used by some of the critics of the NCB is that it is the No Conscience Bureau. The Narcotics Control Bureau, tragically, perhaps at least in this case, appears to have become the No Conscience Bureau, and that should worry us all. I appreciate the fine legal minds and the former NCB chief who've joined us. Should we start a Justice for Rhea campaign?
Hello everyone, this is Rahul Kamal here. Hope you enjoyed this video. For the latest news and analysis, like and subscribe the India Today YouTube channel and don't forget to press the bell icon to stay updated.